The question to Attorney Anglin when he arrives will be, as you know, this forum is being sponsored by the NCADA. Our association is made up of more than 800 North Carolina lawyers and paralegals devoted to advocating and protecting the interests of North Carolina employers, businesses, insurers, and defense attorneys. Many of our members are in the audience today, and they are joined by representatives of our clients from major North Carolina businesses and insurance companies. Please tell us why we should cast our vote for you on Election Day.
I want to apologize to everyone for being late. I got hung up coming out of Raleigh. Hi, my name is Chris Anglin, and as you may have heard, I'm running for the North Carolina Supreme Court. And I would like to thank you for providing me the opportunity today to come speak to you. And I have the pleasure of working with some of the attorneys and adjusters in this room and anyone who may be watching now or at a later date, but I'm sure the feeling is not always mutual. I work in Raleigh and I practice primarily in the personal injury arena. And I am running for the North Carolina Supreme Court in order to stand up for the independence of the judiciary. Unfortunately, over the last several years, I have watched with dismay as the North Carolina General Assembly has attacked its independence. They have stopped at nothing in order to make sure that the judicial branch is nothing but an extension of the legislature. This is in direct contravention to the principles which are set forth in the North Carolina and U.S. constitutions. Specifically, the North Carolina Constitution contains a separation of powers clause. The legislative, executive, and supreme, which reads as follows: the legislative, executive, and supreme judicial powers of the state government shall be forever separate and distinct from each other. A strong and independent judiciary is vital to the strength of our democratic system, and having three separate and co-equal branches of government is crucial to maintaining a healthy and vibrant democracy. And the failure to adhere to these principles results in a loss for both members of the general public and attorneys who practice in this state's courts. I believe that I have shown through my actions up to this date that if I'm elected, I will stand up for an independent judiciary. I will stand up to the legislature when they attempt to encroach on powers of either the judicial or executive branches. I'm also running in order to show that partisan judicial elections are a mistake. North Carolina was the first state in over 50 years to go from a nonpartisan to a partisan race. And initially, the North Carolina Supreme Court was made nonpartisan in 1996. And the trend recently has been to move from partisan to nonpartisan elections, or partisan and nonpartisan, or where the governor will appoint it and there will be a retention election. And partisan elections result in judges like Roy Moore. They also make judges beholden to their parties and special interest groups. This has traditionally been the province of those who are running for positions in the legislative and executive branches. Unfortunately, we have seen more and more at the state and national level the negative ways in which hyper-partisanship has infected our judicial process. And one thing I would like to talk about that has not gotten a lot of attention are some of the things I would like to implement if elected. I practiced at all levels of state trial court and for civil cases, including small claims, district and superior court, and also district and superior court for criminal cases, including state and federal appeals. I've seen firsthand the problems which the judicial system presents to litigants, whether they are individuals or companies. I think one of the primary issues facing litigants is how little support the trial court judges get. And I would propose that every trial court judge in North Carolina should be granted should have a licensed attorney as a law clerk. And they're currently only provided to judges in the appellate and business courts. In other states, it is common for them to be provided clerks. And I think this creates a situation which we've all seen firsthand that can create significant wait times in getting orders on their cases, and also can delay the process when it's unneeded. And it also, given the workloads in some counties, can make it difficult for judges to review all the materials when they are making a decision. And while this may not be fiscally possible currently, I would propose that every judicial district in the state for superior, or every division in the state for superior court judges be given have a licensed law clerk, and use that as a pilot program and see if it can be implemented. And I'm almost out of time, but I think one thing I'd like to mention in North Carolina is the only state in the country which currently does not have a procedure by which a federal court can certify a question to the state Supreme Court. And this makes no sense while it is not available. And also, electronic filing has been available in federal courts starting in 1996. That's 22 years ago. And currently, you can only file in state court, in the appellate courts, and business courts. And in conclusion, I hope you vote for me. And no matter what you do, I hope that you get out there and vote no matter who you vote for. I think it's important as attorneys that we provide information to members of the general public about the importance of the law in people's everyday lives. And I've talked to many people who don't even know that we have a state Supreme Court, or much less that it's voted for. And I know I went over, and I want to thank you very much for your time, and I hope you will support me between now and Election Day.